So there we go. All right. Hello, and welcome to the Gradulting workshop series. My name is Debbie McCuskey, and I am the coordinator of services and programs for graduate student legal aid. And I use she, her pronouns. So this workshop is brought to you by Graduate Student Legal Aid, and we are pleased to present the topic of intellectual property rights. In addition to this workshop series, Grad Legal Aid provides several important services. We do legal consultations, which are for general issues like tenant landlord disputes, auto accidents, contract reviews, and much, much more. Once a month, we have an immigration attorney meet with students to provide consultations. We provide advocacy for students who are charged by the university with a violation of the Code of Conduct or the Code of Academic Integrity. I am a notary, so I will meet you in person and notarize your documents. And all of our services are free. So visit our website and we will post the link in the chat so you can get more information about who we are and what we do and how we could help you. So I have a few announcements to share with you before we get started. You'll see that we have set up automatic closed captioning for those who want to read along. We welcome your questions and comments throughout the presentation, so post them in the chat and direct them to everyone, not just to me or not just to our speaker, but to everyone. Near the end of the workshop, we will post a link to a 6-second survey. So please take a few seconds to answer our questions. Your feedback helps us continue to provide high quality workshops. And we will email links to the survey, the slides, and the recording later this afternoon, but certainly no later than tomorrow morning. And let's get started. I have a poll to share with you. Let me pull that up. All right, I'm launching it. So please take a second to answer a question just so we can understand who is joining us today and what department you're with. All right. Thank you so much. I'm going to end the poll, share the results. I know we've only got a few people here with us synchronously today, but I know many people will be watching this on YouTube later. All right, so we've got some folks from arts and humanities and from business and journalism. Great. Well, thanks for coming today. All right, let's get started with the topic of the day, which is intellectual property rights. All right, so I'm pleased to introduce our expert of the day, Ms. Felicia Metz. She is the Associate Director of Ventures, College Park, and she advises folks on patent prosecution, IP, portfolio development, and licensing. She received her BS in Biological Sciences from the University of Maryland and her JD, magna cum laude, from the University of Baltimore School of Law. She's a member of the Maryland Bar and is registered to practice before the United States Patent and Trademark Office. Ms. Metz has been a speaker with our workshop series since 2016, and we are so pleased to welcome her back today. So it's great to see you again, Ms. Metz. Thanks for making time to talk with us. Tell us more about Ventures and what students really need to know about their intellectual property rights.
Sure. So thanks again for having me, Debbie. Thanks for that nice introduction. And everyone, please, as you have questions, feel free to put them in the chat. I'll try to answer them as they come through. I'm happy to make this more of a discussion instead of talking at you, though I do have slides prepared. So my office, Ventures, we are the technology transfer office for the university. So our mission, our task is to protect and promote the university's intellectual property and help get the products of research out into public use for public benefit. We used to be called the Office of Technology Commercialization, and were rebranded a couple of years ago to Inventions. There's also a Inventions at the University of Maryland, Baltimore, and we work closely with their office there. So as Debbie mentioned, I'm a patent attorney. I've been with the office for about 20 years. Before I was in an attorney role. And so I manage the groups in our office that manage all the IP. We have another patent attorney and a patent agent, our administrative group, and our financial team. And I work closely with our licensing and startup support staff members also in helping get the licenses done when we grant rights to companies to commercialize university IP. So today I'll talk through just some IP basics, a little bit about the university's IP policy, and some other considerations that you should be aware of as you're doing your research or doing your work as a student at the university or after you graduate and go on into the real world, and some things that you should look out for. And please let me know if you have an issue with the slides. So I'll talk about types and rights of IP, the university's IP policy, and other resources available for you. So when we're talking about intellectual property, everything means something different and comes with a different scope of rights associated with them. So trademarks are for protecting the brand name, logo, service mark, and the intent is to identify to consumers the source of goods or services. That if you're buying something that says Nike or something that says Under Armour, that comes with some cachet or goodwill about the company associated with it. That the products might be made a certain way, look a certain way. And so having that brand on it helps the source of the goods. Some requirements to have a trademark: there has to be use in commerce. If you're interested in using one of the University of Maryland marks for some purpose, there is a different office that handles that, and there's a link there. So the university has registered our muscular testudo, though I'm not sure this is used much anymore. You'll notice there's the little R in a circle. That means it's a registered mark. You don't have to register a trademark in order to get trademark protection. You can put a little TM on something to let others know that you think you have some sorts of trademark rights, but there are certain benefits you get to actually registering it with the U.S. Patent and Trademark Office. So if someone is using your mark without permission, then you can take action and get additional damages from them. Copyright is a different type of intellectual property right, which protects original works of authorship fixed in any tangible form. So written materials, literary works, music, dramatic works, including any accompanying music, accompanying words. A copyright, though, really just protects what you've written down, what you take a picture of, what you record. It doesn't protect the underlying ideas or functionality of that. So software, as an example, the code itself is actually protected by copyright. Of course, software didn't exist when the framers wrote the Constitution, but it's been adapted so that software code is protected essentially as a literary work. Now, what the software does, though, the functions of it, that's more under the purview of patents or even trade secrets. So if you want to use code from someone else, you would need permission unless they've released it under a certain sort of open source license giving you permission to do so. If you want to make sure others aren't using your written code without permission, then you should put appropriate notices on that. Software or copyright lasts a really long time. Life of the author plus 70 years, or if you work for a company, it could be up to 120 years. And I think the longer time period of protection of copyright reflects the sort of limited scope of what the right holder can stop others from doing, whereas patents only last for 20 years, and that's because it covers the actual use or function of something. And so stopping others from doing those things, acting on those rights that you have is a shorter time. Copyright originally was a much shorter period of time, but Congress has extended the term. Kind of in the past, every time one of Disney's lucrative characters was about to go off copyright, they'd lobby Congress and the term would get extended. And so every year there's some websites you can find that'll say when things go off copyright. One of the big cases recently in recent history, the happy birthday song. So restaurants to sing happy birthday to you used to come up with their own songs because a publishing company had asserted that they held the copyright to the happy birthday song, and you would effectively need to pay royalties in order to perform the copyright in public. But then it was found that they actually didn't have the copyright anymore because it had been published much earlier than was thought. And so they lost copyright for the happy birthday song. And so now you can perform it anywhere and not have to pay royalties to that company. So copyright gives the right holder an affirmative right to make copies, make derivative works, distribute copies, perform, display, and transmit their copyright. Trade secrets a little different. So whereas trademarks, you can register with the US Patent and Trademark Office, copyright, you can register with the US Copyright Office, which is part of the Library of Congress. Copyright also, though, you don't have to register. It's helpful to put a notice on it. You can just write copyright 2021 and your name, all rights reserved, if you want to put others on notice that you have a copyright. Once something is fixed in tangible form, copyright attaches. My presentation today, copyright attached to that as soon as I typed it. And I did it as a work for the university, so the university owns it. Trade secret's different, though. It's not something that you can register. And trade secret laws vary a little bit state to state. But there is still value in being able to have a trade secret. So you can protect things like formulas, recipes, patterns, customer lists, methods, techniques, processes that have some economic value, are not generally known, and that you're able to keep secret. The point with trade secrets is that companies or individuals who have that trade secret, you have to take efforts to keep it secret. So if you go to work for a company or you're consulting, you might have to sign an agreement that says you're not going to take, business information that you learn at that company and go work for a competitor. And that sort of clause is in agreement so that the company can keep its trade secrets actually secret. If you steal a trade secret, that's technically a crime. But if you reverse engineer something without having copied or stolen anything, that's a legitimate, you can do that and you won't get in trouble for it. And that's the risk companies face then if someone reverse engineers it. Once that happens, then they lose trade secret protection. So WD-40 is one example I like that used to be protected by trade secret until it was reverse engineered. And so now anyone can make the lubricant that's in the WD-40 containers. But WD-40 is a really strong brand name, and so they have trademark protection for their product. Probably most well-known trade secret is the recipe for Coca-Cola, which has lasted a really long time, and the company goes through great efforts to keep it secret. So you have to take reasonable efforts to maintain secrecy. But most of what I'll talk about the rest of the time as far as IP rights and what I deal with most often on a day-to-day basis are patents. And so patents protect inventions. They can be something that come out of conducting research, that you have an idea for something, and through your research, you're able to make something that accomplishes some problem, or they could be accidental inventions. But most inventions, I think, that that we deal with are those that come about as a result of finding a solution to a problem. I do like the Velcro story. Supposedly the inventor thought of it, the hook and loop design, to have a fastener while he was out walking his dog or pet, and burrs were sticking hooked on to his pet's fur. And that's how he came up with the idea for Velcro. So a patent is something that you do have to file. You do have to register it with the US Patent and Trademark Office to get a US patent. And it's a right granted by the government that allows an inventor or owner of that patent to prevent others from making, using, selling, or importing into the country that invention without permission. And it's what's known as a negative right, because you might not necessarily be able to practice your own invention. Say your invention is an improvement of someone else's patented invention, and you need to practice that original patent holder's invention in order to practice your improvement. You might not even be able to practice your own invention, but you could prevent others from practicing it. So that's why it's known as a negative right, whereas with copyright, you have an affirmative right to make copies, make derivatives. Here, your right is to prevent others from doing things. And it only lasts about 20 years from when you file a patent application. You can get certain extensions of time if the patent office is delayed in examining the patent application, or if you have a drug patent and you have to get FDA approval, you can get certain extensions there as well. So in this country, we have three types of patents: utility patents, which protect processes, machines, articles of manufacture, compositions of matter. And those things also have to be new, useful, and non-obvious. And these are all things that you have to convince the patent office you've met. You can also get a patent on plants. University of Maryland has patents on raspberry varieties. We have one apple that it's called Antietam Blush that some folks in my office have seen at nurseries around. Plant patents have to be a new variety bred that's asexually reproduced, distinct and new from anything else. You can also have a design patent in this country, which protects the ornamental design for an article of manufacture. Well-known design patents, Crocs shoes have design patents. The iPhone, Apple has design patent on the curved corners of the phone. Instead of a straight 90-degree angle, it's curved, and they have a design patent on that. Most of what the university files, though, for patents are utility patents. One important thing to think about, too, if you have an invention and are filing a patent, is figuring out who's an inventor. And there's a legal definition, and it's someone who contributes to the conception of the invention. Well, what is conception? And that's having an idea in your mind of a definite and permanent idea of the complete and operative invention. And it's sufficiently definite and permanent when someone in your field, someone of ordinary skill, would be able to reproduce the invention without extensive research or experimentation. And so if you have an invention and you file a patent application, but you intentionally keep some piece of it secret because you want some sort of advantage, that's not okay. Because remember, the deal with the patent office is that for this 20-year limited monopoly that you get to exclude others from practicing your invention, at the end of that time, it's dedicated to the public. And so that anyone can make, use, and sell your patented invention. So you have to include a full description, all details in the patent so that others can practice it. And so joint inventors have to contribute to something that's claimed in that patent. And so as you're working at the university, if you are, say, a graduate assistant or a lab assistant in someone's lab, and you're just following instructions that somebody else gives you, even if you're the one actually doing all the work, if you haven't contributed to the design, you haven't made any improvements, you're just following instructions, that doesn't make you an inventor. But say you are carrying out instructions for someone else and you see a problem and come up with a solution to improve it, and that improvement piece ends up in the patent, then you would be an inventor. So joint inventors don't all have to work together. You don't have to make the same or equal amounts of contributions, and you don't have to contribute to every claim in the patent. And so if this ever comes up as an issue for something you're working on campus, we can help figure out who's appropriately an inventor or not. One patent, I know this is hard to read, but this is an example I like of a relatively simple invention that the university got a patent on, and we were able to convince the patent office that this was a new, useful, of course, and not obvious invention. So we have a retired faculty member who is an expert on raptor eyesight, so how eagles, hawks, other birds of prey see. And so there's a problem with the windmills, the giant wind farm windmills, of birds running into the blades. And he thought, well, how birds see is different than how people see. So for us, if you're looking at a ceiling fan or a desk fan that's on, you don't see the individual blades because of motion smear. While birds have the same issue with the big wind farm blades against the sky, they can't see the blades because of motion smear. So we thought, well, let's paint patterns, colors, different designs on the blades, something that they can see. And so if the blades are painted, if they can see it, then they won't run into them. And so we got a patent on painting blades with these designs, patterns, and even different colors. And the university then licensed this to a company out west that has wind farms. The problem, though, they were only painting the blades every time they serviced one of the windmills, which wasn't very often. So I don't think they ever got the data showing that it really worked like our inventor thought it would work. But this is a good point too, that what's in a patent doesn't necessarily have to function or work like you think it will. You just have to convince the patent office that you have an invention and that it's new and non-obvious and has some sort of use. And so even though this was relatively simple, no one had thought to do this before, and we convinced the patent office that this was not an obvious thing to do and thing to have. Thinking about then who owns intellectual property, it depends. And so here at the university, we look at who are all the inventors or authors on something in the case of a copyright. And we have to consider, what does federal law say? What does the university's policy say? And if there's any other contractual agreements, including employment agreements or visiting researcher agreements that come into play. So for inventions, there's a federal law called the BiDol Act, which is 41 years old this year. And this allows inventions made with federal funding that the university who receives the funding can own that invention. Before the BiDol Act, inventions made at universities in the country using federal funds, the government would still own the invention, but they didn't have the resources to commercialize potentially great inventions. A lot of things were being shelved, couldn't be developed. And so this law enables the place where the work happens to own the invention, even though it's made with federal funds. So the University of Maryland can own inventions made with government-funded research, but as part of this, we're encouraged to collaborate with companies to promote the use of university research. We're encouraged to license inventions to small companies, and we're also required to share licensing income back with inventors and use royalties to further more research activities. And so our IP policy really codifies this for the university and lays out then what that royalty sharing scheme is. So if you're a grad student and you have an assistantship that's being paid for with federal funds, and you have an invention, then that would kick in the university's ownership rights in that invention, because we have these obligations back to the sponsor. So when we're looking at who owns something, first we're looking at each inventor or author, where are they employed? We look at the assignment obligations of each person. And if there's more than one owner, then it's jointly owned, and we try to work out agreements with the joint owners. And we also are looking at if students are involved, or are you employed by the university? Was the IP made in the course of just your research or academic activities, or were you being paid to do something? And all of this we consider when figuring out who owns what here at the university. And the IP policy goes through discussion of what's a traditional scholarly work, administrative works. I won't go through this in detail, but you should know it exists. But generally, for students, things that you do, work that you create as part of your research and academic activities, you own, not the university, unless one of these other provisions is in place. So when you're writing your thesis, you hold the copyright to that, not the university. But if you're being paid to work on a certain research project and have an invention out of that, then the university would own that invention. And so work that you, for traditional scholarly works, these are papers, your thesis, course content. If you're doing curriculum for a class, the student would hold copyright unless you're being paid and tasked to specifically do something, or if it's a required deliverable of sponsored research. I think of it as if you're paying your tuition, if you're paying to come to the university, you own that IP, but then if the university is paying you to do something, then the university would own that work. The university's IP policy splits up those traditional scholarly works, talks about that separately. And then when it comes to inventions, software, data, and materials, the university would own it if it's made in the performance of sponsored research, supported by other university funds, made for personal purposes using significant resources, or if not owning it would be some breach of an agreement that the university has. But as students, you own if made in the performance of your academic or research activities. And we have a checklist to try to help. So if IP is not created under sponsored research, not created using other university funds, not created using significant resources, then the individual person generally owns the IP. As students, though, even if you're using significant university resources, if it's for your academic research activities, you would own it. If there's ever a question of you're not sure, please come talk to us and we'll help figure it out. We're not trying to own things that the policy says we don't own. If there is something you own as an individual and want the university's help, we can certainly work something out there too. So the right to use IP as the owner, remember, for patents, you have the right to exclude others from making, using, selling your invention. As the copyright owner, you have the right to reproduce, prepare derivatives, distribute copies, perform, display, transmit. If you have data or materials that's not really protected by any sort of intellectual property right, but there are certain sort of tangible property or contractual rights that you have as far as how data or materials get used. And so the owner can grant permission to others to some or all of those rights, and that's a license. Think of it like with real property. If you own a house, you can do whatever you want with that house generally. You can sell it, you can have people come stay, you can paint it, you can tear walls down, you're the owner. But if you then want to sublet part of your house, say your basement, you do that through a lease, and the renter has a license then to exploit part of your rights for some limited period of time. And that's the same thing with a license, that you're not giving up total ownership, but think of it like a lease then, where you're giving someone permission to do something for a short period of time in exchange generally for royalties back to you if they're, say, making a product. And so if someone is exploiting your intellectual property rights without permission, that's an infringement. And so this is something to be aware of too, as you are doing things, you're incorporating others' work into yours, you need to make sure that you have the right sort of permissions needed. So I think there was a question submitted ahead of time about downloading pictures you find online. Generally, copyright does attach to pictures that people post online. And so if you want to use someone else's picture, especially if it's for some commercial purpose, you want to make sure you have permission to do that. As far as software goes, if you're incorporating code from someone else, if they've posted it online and made it open and available and there's no license restrictions, then you're free to do that. But they might have posted it with license restrictions. And so you want to pay attention to what's usually in, the README portion when you're downloading some software of what those restrictions might be. You'll notice too, when you're going to access some websites, you have terms and conditions you have to agree to. Most people don't read those and they just click OK, but often there's some sort of license right embedded in those click-through agreements. One exception to infringement for copyright is fair use. And so the fair use exception carves out an area where people other than the owner of the copyright can use the work without infringing. And so it's fair use if you're using someone else's copyright for criticism, commentary, news reporting, teaching, scholarship, and research. But there are some limitations. And so in figuring out if something is really fair use or not, you have to consider the purpose and character of the use, including whether it's for commercial or nonprofit purposes, the nature of the work, the amount and substantiality of the portion used in relation to the work as a whole, and effect on the use on the potential market for the value of the copyrighted work. So especially if you're sharing things in an online class platform, if you take an entire textbook and scan it and copy it in and post it on the site, so your 150 students can have access to the textbook without having to buy it, that's probably not a fair use because you've copied the work as a whole. You're impacting the market for purchases of the textbook. So that's probably not okay. But say you are taking out 2 pages of a 150-page book and you're sharing that might lean towards being a fair use because you're not taking the work as a whole. You're not putting a dent in the market for the textbook. And if it's for teaching or research, that might be okay. So when in doubt, we can help you work through this, or General Counsel's office might be able to help as well to figure out if something is fair use or not. I don't know if it's still an issue, but no, the university had an issue a few years ago with sending note takers into classrooms to basically copy down all of the curriculum and slides that were being given in classes and then selling it without permission. And that was not a fair use. And so if anything like that ever comes up, you should bring it up with General Counsel, or you can start with our office as well. I see there was a question. Suppose I have an idea for useful software. The idea is not obvious, but it will seem obvious once it's presented. How do I know if to pursue or not? Good question. So you can still get patents on something that's in hindsight is relatively simple, but that obviousness requirement with the patent office, often that happens. If you're filing something that's a combination of multiple things that already exist, and the patent examiner says, well, this would have been obvious to do this at this time, you can overcome that rejection by submitting evidence and examples like for why no one else had done it before. So maybe people thought it would function opposite of how it functions for you, or they thought maybe it would just give a 2-fold increase in performance of whatever it does, but you've shown it's a 100-fold increase, or it's taken 10 years, 20 years of development to get to this point, to combine things in a way to make them work. And things like that can help overcome an obviousness rejection. So just because something is simple doesn't necessarily mean that it's not obvious, but doing a prior art search, so looking at what other patents, what other papers are out there, can help in figuring out whether what you have is potentially patentable or not. So hopefully that helps answer your question. And if you think, well, maybe there's greater value for business in keeping it secret because maybe the value is beyond 20 years and nothing's been published, then you could consider keeping it trade secret instead of filing a patent. Back to, though, the fair use exception for copyright infringement. So fair use is only for copyright. There is no fair use exception for patents. This comes up a lot in the university environment because you might be working on someone else's invention, trying to improve it. There really is no research exception. In reality, it's unlikely that if somebody has a patent that they're going to come after you for research use. It could still happen. The challenge, though, is how is that patent holder being damaged? So if you're not selling anything, not making money off of it, it's hard for them to pursue any action against you. Licensing jointly owned IP, this is another caveat. So if you have a patent that's jointly owned, both joint owners can license and exploit those patent rights without having to pay the other joint owner. That's called a duty to account. But with copyright, there is a duty to account. So if you've developed software, or you've written a book, or you've written a screenplay with a co-author, you want to make sure you have an agreement worked out for how potential revenue will be shared. And look at language in contracts, license and assignment language, publishing agreements. When you go to submit your thesis and publish it, there's going to be copyright, probably assignment language to the publisher. When you submit papers to a journal, you're often then giving them rights that they have the sole right to publish that paper. If you're asked to sign a non-disclosure agreement, often companies will put in IP license and assignment language there too. So keep a lookout for that. And if you're not sure what something means, please ask. Here at the university, we want to make sure that people can still publish, that they're not going to be prohibited from doing that. But if you're doing outside consulting, we can try to help just to see if it aligns with your role at the university, but otherwise just something to be aware of as you go and work elsewhere. Look at what the language is in employment and consulting agreements, especially if you're working for a company. Some more with copyright and open source software. So remember, you have copyright in the written code. An open source license is not saying that the software has no copyright. That would be public domain if you say there's no IP rights attached. But software released under an open source license, the original author saying, yes, I have copyright in it, but I'm letting others use this in a very permissive way. And the licensing scheme is the open source license. So the author grants permission for others to exploit the copyright so they can make copies, distribute, make derivatives, and most might then have requirements for how you give attribution. Generally, then if you're making derivative, then you have to follow the same license scheme. There's a helpful website that we've used to help figure out what open source license might be most appropriate. Since it is possible that a single piece of software might have patent rights and copyright attached, some open source license talk about what other users can and can't do as far as the patent goes as well. Some open source licenses prohibit commercial use too. If you use some code incorporated into yours and then are trying to sell it, but you've taken code that says you can't commercialize, you have to be mindful of that since the license needs to flow down to the derivative works. So if you ever have a question about what open source license makes most sense, we have folks in our office who can help with that too. More things that my office does. So for the university's IP, we take care of the marketing and licensing, help in the formation of startup companies based on that university IP. We do the patenting. We have a budget to pay for the patents, so it's not like people have to pay individually. We take care of all that government reporting for the federally funded inventions and then distribute royalties that we get back from licensing. And I think one link that'll be shared, we also do a series of workshops. If you're thinking about starting a company, interested in entrepreneurship, through Startup UMD, we have a whole workshop series. And so there's some more videos on YouTube and a schedule then where you can join more workshops live. That'll be shared with you at the end. When we do get intellectual property disclosed to the office, in figuring out, are we going to patent something, we consider, one, is it patentable? Is there some other form of IP protection available? But more importantly, is anybody going to pay for it? At the university, the research that's done, it's all basic research. Things are very early stage, and it's going to generally take a lot of work to get something ready to be a product to sell or manufacture. And so we have to do our best to figure out, one, is there some form of IP protection available? But more importantly, is anybody going to pay for this in the near future, or is it going to be 10 years from now? Does it make more sense to create a company around it to do further development, or can we license something straight to an established company? So it's sort of our decision tree. As creators, as authors, as inventors, always want to remind people to keep good records, keep good lab notebooks, keep track of your emails. This is important if you think somebody is using your IP without permission. Where you're incorporating third-party works into your own, make sure you're getting appropriate permissions. If something is owned by the university or you're not sure, disclose timely. For getting a patent, things like publishing can compromise patent rights, and we never want to hold up a publication, so we can file certain types of patent applications pretty quickly. And if you are patenting something through the university, you're the expert, we want your help through that process. And so keeping us updated and helping us on the technical side of things is really helpful and important. And if you are collaborating with someone at another institution or a company, formalizing, having a written agreement about what expectations are will help down the road as well. Campus has a lot of great resources, and this might actually be a little bit out of date, but there's proof of concept funding programs that are available. We have incubators. If you're not familiar with I-Core, it's an NSF funded program to help figure out if you might have an idea for a business based around IP. And this helps you figure out really if the value proposition is what you thought it was. So it's sort of forced customer discovery. You have to make a lot of calls. You're not trying to sell at someone, but really ask questions as to, the solution that you have to some problem. Is there really a market for it? Do customers really want it? Or even if your way is better, maybe there's a cheaper way out there. So even if it's not as good, if it's cheaper, maybe the market will lend towards that. Venture fairs, pitch competitions, at least when things were in person, entrepreneur office hours. Through Inventions, we have 3 entrepreneurs in residence who are available to meet with people too, thinking about forming a company, and they're seasoned entrepreneurs and give great advice. So those are some other campus resources available. My office, Inventions, we fall under the Division of Research. MTech is under engineering. Academy for Innovation and Entrepreneurship does more education piece on campus. And Digman Center for Entrepreneurship in the business school deals more with student entrepreneurs, and they have several competitions as well. So that was it for my slides. Happy to answer more questions, either by chat or if others want to to speak up. I think Debbie put in the chat the link to our workshop series, and there's also a link at the bottom of the page to our YouTube channel where previous sessions are posted. So pursuing a patent as an individual is expensive. Yes. So getting a US patent, you as an individual inventor, technically you can file directly to the patent office, and there are some free resources to help solo inventors. But I definitely recommend getting a patent agent or patent attorney to help with the process. And so paying those people, that's where things get expensive. The filing fees themselves, just with the patent office, might be a couple $1,000s. You pay for filing and examination and search fees. But then paying a person to do the work and navigate things with the patent office could be, between $10,000 and $20,000 just to get a single US issued patent. If you're filing international patents, since patents are country by country, right, things can get expensive very quickly. What patent services, what scope do we provide that I mentioned? So my office, we file what's called provisional patent applications in-house. Those are relatively inexpensive for filing. You don't have to draft claims. If you've looked at a patent before, there's a background that explains problem being solved. There's drawings, and then claims, which are in kind of legalese, really what your invention is. And so provisional patent applications don't need claims, but they're pending for 1 year. And so you have a year to figure out if you're going to go for the full patent. And so if someone is going to publish very quickly, we can file a provisional patent application in-house. And so that's $100, $200. And then if we decide to pursue the full patent, so if we think something's going to get licensed soon, or that it's a really great technology and we think there's potential downstream, then we'll send to outside counsel that's engaged by the university. And again, if we've done that assessment and think it's worth the university filing on, then the university pays for it. If we decide not to pursue a patent on something, then we'll release rights either back to the sponsor if something is funded by an outside sponsor, or rights directly back to inventors for them to pursue on their own. Any resources to get to know existing patents, inventions, IP to make sure we're not unintentionally infringing. So the US Patent and Trademark Office website, you can search patents there, uspto.gov. Google patents, I pretty much start every search just with Google too. That's a great place to start. In any search though, you can't find everything. And so you have to make a decision of how diligent you want to be in searching things out. The university is also home to, I forget what it's called now, it used to be a patent and trademark depository library. But through the engineering library, we have access to the same search databases that patent examiners use. So if you want to do a more in-depth search, the libraries can help with that. But yeah, I would suggest starting with doing a Google patent search and start there, or directly on the USPTO site. Many other countries have their own searchable databases as well, and that would be a good place to start. So if you can search, keyword, specific art units. So if everything that's filed in the patent office is assigned to an art unit, so if you have a patent on umbrellas, it's assigned to a group that has a specific code for umbrellas. So things get pretty specific there. So if you know the art unit, if you know a person or a company working in the field, you can also search by inventor name and search by owner name, which would be the assignee or applicant. So lots of different ways to search. And if you want more guidance on how to do better searches, the libraries here are a good resource as well. Great questions today.
Yep. Any other questions?
Resources to help students with patents, copyright for ideas they developed and want to pursue independently. Yeah, so if it's something that you own and the university doesn't, there is an IP clinic that the University of Maryland School of Law runs. IPEC, I want to say, is their acronym. But that's a free service. They have an intake form. So if you are a student, they might then check with me again just to make sure the university doesn't own it. But they can help with doing patent searches. They have law students then who can file patent applications for you. They do trademark registrations. And so that's a clinic through the law school. That's a good free resource as well. Is it important to keep an idea secret for a while? I've heard venture capital people say, we don't sign NDAs. What's our experience? Well, at the university, I think it's hard to keep things trade secret because our goal is publishing and dissemination of knowledge. I had someone a few years ago when we gave an opinion that we didn't think we'd have an easy time getting a patent on something. They said, well, let's keep it a trade secret then. Well, they'd already published and the device was in a lab in a part of a building that had no locking doors that anybody from the public could walk in. So to me, that's not really keeping something secret. But yeah, you'll hear that from certain investors that they won't sign NDAs. And so where you can keep ideas at a high level when you're talking about something, not giving details away that somebody else could reproduce it easily. That's the way to go if you're talking to investors. And often with, when we're marketing something to a company and they won't sign an NDA, we'll keep the discussions at a high level, but once it gets to a certain point, if they still refuse to sign our standard confidentiality agreement, then it's often not worth pursuing the conversation.
Okay, any other questions? All right, it's quiet. Well, I think we'll wrap it up now. Ms. Metz, you are such a great resource for, the good work that graduate students are doing at the university. And thank you so much for sharing all of the resources on campus. We will be sure to share that with students after the workshop. And I know our attorney, Zach, will share them in his consultations with students. So thank you so much for joining us today, to Ms. Metz and to everyone who attended the workshop and who's watching on YouTube. I ask you all to take a few seconds to do our post-workshop survey and give us your feedback. And I also want to let you know that next week's workshop is all about campus safety. We will be welcoming Chief Mitchell from the UMD Police Department. So until then, have a great week and let us know how our team at Legal Aid can help you. Bye-bye.